you through the last part of the training today, the fourth session. And thanks a lot, Aaron, for providing us all with AI literacy, something mentioned in Article 4 of the AI Act. So we know a lot more, which is very useful to understand our daily work, I think, in civil society and equality bodies. And in the last part today, it's not going to be more than 15 minutes, so I'm going to be brief, but let me remind you all that we are working on explainers. So these are going to be short documents that will be published. We're going to present them in the third webinar on the 29th of April. They're going to be published around that date where we go a little bit deeper in the technical, legal, and other issues. So look out for that. So now back into the last part of this before we have the Q&A. And this is about legal challenges in AI discrimination. Let me start to involve all of you to catch your attention with a question. You don't need to disclose anything personal, obviously, so only say things that you feel comfortable saying. But the question is, who of you was personally confronted with an AI-based discrimination? Have you been personally affected by an AI recruitment system, by not getting a loan, not getting a mortgage? Ask yourself the question whether personally you have been faced with such a situation, or whether you know somebody. There's a question we need to keep in the back of our mind because it helps us also to identify where the problems are. If you have anything to say on that, I mean, please post it in the chat or raise the point in the Q&A. It would be interesting to know because there are not so many cases out there. And so you have to look out in the real world what's happening. The second question, the same question, who of you was professionally confronted with AI-based discrimination in your capacity as a CSO, bringing forward a case, helping victims to identify what's going on an equality body? And again, don't disclose anything that you cannot disclose that is not public, obviously, but ask yourself the question, or was there a case where you thought, this looks like algorithmic discrimination? I'm not sure. I don't know. Where you had the feeling. And this is exactly the questions you need to ask because it's all about knowledge. Knowing about an AI decision. Very often we don't even know that an AI system is behind a decision. When we apply somewhere, often some form of AI or simple algorithm is used, but we are simply not aware. So we cannot even know. And that is very often the starting point. So it's about knowledge. And then once you know it, it's also about access to information. How do you actually access the algorithm? You need to understand the information, but also the AI system. And that is what Aaron tried to explain to you. We kind of need to understand how it works to first find out where do we get the information? How do we get it? Is it IP protected? Can you access information by Google, Amazon, Facebook, and co, or by an SME? How do you do that? What are the challenges? And all of that is something you need in order to build a case. Then in the end, you need to know not only the technology side, but also what are the legal rules? What do I base this claim on? How do I complain? Is it national law? What is foreseen in EU law? Can I use the AI Act, consumer law, class action? What can I do? What are my options? All of that, access to justice, how you can complain, whether you can complain on an individual basis or on a collective basis, you will see in the second webinar on the 9th of April. So stay tuned for that. We're going to be much more in detail how a complaint based and what are the differences. But some of the stuff that you find in the AI Act, I want to share with you already now. And notably, it's the stuff that is important for you as a civil society organization or as an equality body or an interested person. And this is the difference, the main difference between the AI Act and non-discrimination law. You have to be clear that the AI Act only indirectly ensures equality. So you cannot base a non-discrimination complaint on the AI Act, basically. That is something you cannot do. That is something you need to do in your national context. You need to use national or EU non-discrimination law, go to your equality body, complain, have a court procedure, all the measures that are foreseen under national law. If you have a traditional complaint on the ground of discrimination, even if this involves AI, this is the route to go. However, the AI Act can be indirectly helpful. You can complain for any violation of the AI Act, which is a regulation. So if you're an affected person, legally or in the same manner, it doesn't need to be legally necessarily. For example, if you have an AI recruitment and you think you have been there's a violation of the AI Act, you could make a complaint to the national authority that is competent. But that's not a complaint based on non-discrimination law. So that's interesting to know. Then, however, and we're going to come to that in the next session, there are ways where authorities can cooperate. There could be information sharing, and information could be used that is available on the basis of the AI Act that can be helpful for a complaint. So there are many advantages. To give you a concrete example, there will be a EU register, Article 71 of the AI Act, where some AI risk systems, they will be published. So you find some information there that you can use for finding a case, building a case, and if you want to know more. There are others like bias audits for high-risk AI systems that need to be published. So there are a lot of tools in the AI Act that can be super helpful, but you need to be aware of them and you need to kind of use them. And then there are, of course, some limitations of which authority cooperates with which one, what is legally possible or not. That might also vary in a member state, but you need to be aware of that they kind of can interact to your advantage. So these are, in a nutshell, the advantages of the AI Act and the disadvantages of the AI Act, that it can help you, but it's not a fully fledged mechanism to ensure algorithmic discrimination. Far from it, but be aware of it, and we're going to discuss some of the provisions. One of the major provisions is, of course, Article 6, and that's high-risk AI systems. I briefly were talking about it earlier. There are many use cases. If you look into Annex 3, there are many use cases where this potentially applies. And just to give you the example of the labor market, where recruitment AI could be an example, this is more or less the same as for example, the Directive 2006/54 that applies to gender-based discrimination in the area of employment. So there is a parallel here, and that's also why it becomes super interesting for you to use it in a discrimination case, because the areas are very similar. And we all know these are two examples that you see here on the slide of automated software being used in the US, and also surveillance technology that is increasingly being used. So be in the watch out for all these technologies, and I know many civil society organizations are working on these issues, so yeah, you're familiar with that. But also equality bodies, I think, need to be aware of that because their future cases might lie if people are affected. And hence the question whether you personally have been affected by one of these situations of potential algorithmic discrimination, or whether you're working on such a thing, because there are potentially many cases out there that are not being discovered because people are not aware of it. So it's all about knowledge transparency, which is key alongside the legal rules to actually start reflecting and doing something about it. I said knowledge, access to knowledge, transparency is very important. Some of the things Aaron explained. For high-risk AI system, the AI Act has a clear advantage because there are specific requirements. So we have the most complex regulation for AI systems is certainly for high-risk AI systems in the AI Act. And if we look into Article 6 jointly with Article 8, there are few requirements that need to be done by those who use high-risk AI systems, and obligations also for providers. And that is notably risk management system. So that's the things you see on the left-hand side. They need to have a risk management system. They need to have a form of data and data governance, technical documentation, record keeping. This was addressed a little bit by Aaron. Transparency information. So they need to provide information how the AI system works. They need to keep the records. They need to technically document what is happening. So there are, for example, model cards or data sheet cards to explain what data sets are used, how they are working, what model is used, what variables are used in the models, how does the decision process work. And all of that is actually very useful to understand a potential case of discrimination, because there you have information, or you find it, or you potentially know what a company used to make a decision, for example, in recruitment or credit approval. And then you can ask for them, because you need to be aware what are the documents available, but also what are the legal rights. And if there is a violation, you could potentially ask those things, because some of these need to be published. And so this can be very helpful. And so also the obligations for providers like document keeping or automatic locks is very vital. Fundamental rights impact assessment, I mentioned it already, Article 27. It's an obligation only for providers that come from the public sector, so public bodies, or when it's procured, or I mean, if it's used for a public body. If a private company uses an AI tool on behalf of a public body, then it can also be a requirement. So it's very restricted, and it's only high-risk AI systems. But in these cases, you will have a fundamental rights impact assessment that helps you, that will be available, that you can look into, and you can better understand the process, because a fundamental rights impact assessment is kind of screening the whole process of the AI decision. And if there is a legal obligation to do so, it's very useful. And maybe even some companies use that on a voluntary basis, because they incorporate by design. They do it on their own because they see it's useful to make their product more attractive to consumers. So it's good to know about that, whether it's a legal obligation to do so or whether it's something nice to have that companies do a long way. So please, if you have a case and you know it's a high-risk system, you think it falls into this category, you have to look into Annex 3 jointly with Article 6. There are all these tools that might help you because this is the requirements of the AI deploys if you use that, or for some of the AI providers. So how to comply with the AI Act, or better, how to use the AI Act? There are many guidelines out there and guidance and a lot more still to come. So I don't want to now list all of them because there's a lot, but I rather the aim is here to draw your attention to the fact that basically go to the AI Office website, see what's happening there. Go out to other CSOs and organizations, check out our explainers that we'll be providing, and hear about cases that are happening. You can go to the Equinet website where cases are reported. You can go to other information sources, but this is important to be aware of similar cases and also court cases to be able to better understand how to interpret them. Because of course, now the guidance is very limited in terms of non-discrimination law, but also in terms of how to basically implement, to apply the AI Act, because there are not so many cases. So look out what is there and basically stay tuned, because there will be many implementing acts coming. There will be AI Office guidance coming. I gave you the example of the guidance on the definition, the 12-pager that explains you more what is an AI system. So there will be many more documents coming, and that is, of course, the first stop to go to if you want to interpret the AI Act and have inspiration for algorithmic discrimination. So that's just a kind of invitation to follow that, and there's going to be a lot. A second point, very important, is the timeline, key dates of application. You probably all know that not all of that is coming immediately into effect. Entry into force was on the 2nd of August 2024, but some of the provisions will only be applying in 2030. So that's 5 years from now, or 5 years and a half. And that is, for example, the exception for the public sector, or if an AI system is put into service before. This only applies in 2030. So there is, if a public sector is using an AI system, it's Article 110 that foresees some of these exceptions. They only need to abide by it in 2030. So that's a long way. And that also means the discussion on interpretation is moving. A lot of the stuff has not been decided yet. The prohibitions have come into effect already. February 24, high-risk AI will be in August 2026. And GPAI models, transparency requirements, will come effect in August 2027. So you see, the discussion is not too late. It's never too early, of course, to prepare. And some of the thing companies have been implementing already, but the timeline is quite long. And after that, and that is something also that was clear when Aaron presented, is not only AI developers need to change their systems, but also the legislator needs to do how this works, what does need to change, and so on. So it's important to keep that in mind. Look at the timeline, Article 110 and others. There are many brilliant timelines who explain in more detail when will what apply, and that's important for companies, but also, of course, for the enforcers that applied it. In terms of who is doing what, it's always interesting to look into the key actors. So I mentioned the AI Office. That's the kind of central body that is centralizing a lot of information and some of the legal tasks. It was enacted by an AI Office decision of last year. And it's basically, one could say, what is more EU relevant is the competence of the EU office, and what is more in the member states is the competence of the member states. And that's certainly true for general purpose AI system, where it's the exclusive competence of the AI office. But the big chunk of the rules is actually enforced by the Market Surveillance Authority. So every member state defines a Market Surveillance Authority. And we're going to come back to that in the next session. We're going to have some slides that specify that in detail because it's very interesting, notably because of the cooperation with the national bodies that do fundamental rights and equality and non-discrimination protection. That's Article 77. So on that cooperation, we're going to talk a lot about it because it will be very important in your daily practice, whether you're an equality body or civil society organization. It's good to know who to talk to and who is doing what, to understand when you have a case, who to flag it to, who cooperates with whom, what are the access rights of equality bodies. So we're going to dive a little bit into that. And Article 77, as I said, it's the potentially equality bodies could fulfill the role of an Article 77 body. It's a body that will have specific rights in terms of access to information, but also in the end, they can basically open the black box of an AI system. That is a very strong right, together with the Market Surveillance Authority. The details, because it's very important, we're going to talk about it in detail in webinar 2, and also to draw your attention to a publication done by Professor Bernd Mittelstadt from Oxford University that was done in the framework by an Equinet member, the German Antidiskriminierungsstelle des Bundes, commissioned that study, and it has been recently published. So please look into that. It gives you very useful guidance, specifically AI discrimination, how to handle that. It's a very nice publication. But we're going to go back to that with some very practical things in the next training, and also in the explainers, you're going to find some of these things. So basically, I will finish here and kind of ask you whether you have any specific aspects or questions that is valid for Aaron's presentation or for mine, for all the 4 sessions. We're going to go open up the Q&A soon. Just to finish with 2 reading suggestions, if you think about how to put some guardrails on AI, a very interesting read is The Guiding Human Decisions in the Age of AI by Urs Gasser and Viktor Meyer-Schönberg, or a more societal approach is In AI We Trust by Helga Novotny, a very prominent researcher in AI. So I invite you to read all of that if you have time. And now I give the floor back to the colleagues, and I think we can probably start the Q&A, and you can speak, I guess, or raise your questions in the chat. Thanks for listening.